Go live.
Thank you.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much and good morning. So the first case we have to hear this morning is Commonwealth versus Claudiano Santana, number 2021-0413. And as is apparent, we are hearing this case remotely on our Zoom platform. The panel today consists of myself. My name is Ariane Buno. I'm joined today by Justice Peter Rubin and Justice Maureen Walsh. You each have 15 minutes to present your argument. All the rules that apply as if to oral argument as if we were in the courtroom apply here. So you have 15 minutes, as I just said, and there is no rebuttal. So Ms. Kelly, we're ready to hear your argument.
Okay, thank you, Your Honor. May it please the court, I represent Claudiano Santana in this matter, and all of the issues that were raised in the petition or brief go to the credibility between the defendant and the complainant. This is not a case where there was any physical evidence or eyewitnesses, so the errors that came in, one was that Mr. Santana's immigration status came in by a question, the very last question the prosecutor asked him about being here illegally in the country, which I believe had a very detrimental effect and it's considered highly prejudicial. There was no basis for the question other than to elicit prejudice and bias from the jury. And to exasperate that, on the other side of the equation, the complainant's testimony was bolstered both by calling Detective DeLuca and the prosecutor in their closing arguments making comments about him being an experienced detective in sexual assault cases, and that after his investigation, Mr. Santana was arrested.
Can I ask you a couple of questions, Attorney Kelly, about the questions regarding your client's immigration status? There was some conversation and discussion between the parties before the case started as to what was going to be introduced in terms of his background. And my understanding from the transcript, and you can correct me, is that it was defense counsel that wanted to raise the issue of his transportation or his entry into this country, if you will, because it had been paid for by the victim's father, and he thought that the defense counsel thought that this showed bias. So, to a certain extent, the issue of immigration and status came in initially in the defendant's case. Is that, would you agree with me there?
Yes, Your Honor, but I think whether his status was illegal or legal was not brought in. In fact, someone can sponsor somebody to come over the country, or he could have paid him to help him come to the country and still been here illegally. But the issue of whether he was illegal or not was not addressed in his direct testimony. It was brought out by the prosecutor. And the trial court did overrule defense counsel's objection to that, who, like you said, the defense objected immediately. The objection was overruled. And while there was a curative instruction given later, there was no instruction about that the jury could not consider it in weighing the credibility of the defendant, which is where the real risk of prejudice comes in, as the cases that I presented in the brief discuss, that the danger is that it's going to make the jury think this is a bad person. They already have bias against people being here illegally. And while the jury may have known that both the complainant's family and the defendant were immigrants, It's the fact of him being an illegal immigrant that only the prosecutor brought up was that what was prejudicial. In addition, there were several questions by the prosecutor about his inability to speak English, which I also think is going to play into jury biases about people in this country not learning English. There was no reason for any of these questions other than to be playing to bias against illegal immigrants and people that don't learn English after being in this country for a number of years. And as I stated, I don't think that the current instructions were enough to unring the bell, as the court has noted, when it's highly egregious prosecutorial misconduct. The jury heard it. And again, they weren't told, it was not, the objection was not sustained. The judge did not strike the testimony. It was still part of the record.
Counsel, can I interrupt for a moment?
Sure.
Would you agree, first of all, I think it's undisputed that this issue of immigration status came up prior to the jury being impaneled, and it appeared that the Commonwealth was concerned about this evidence coming in, correct?
I'm sorry, you just froze, so I didn't hear your question.
Okay, so you agree with me that this was an issue raised prior to trial and that the prosecutor was concerned of how it was going to be crafted before the jury, correct?
That is correct.
Immigration status, okay. And then the defendant takes a stand, and the defendant expands upon what was believed was going to be his testimony and says, the victim's dad threatened to have me deported if I didn't pay the 6% or the 5%, whatever it was, correct?
Correct.
Okay. So that door was opened a bit about motive, about the victim's dad's motive as to why these charges were present, because of a debt and a threat to deport by the defendant's own statement.
Well, I think, as Your Honor pointed out, when they discussed it previously, that was the reason that the defense stated they wanted to get into it, is that there was a motive because he owed the complainant's father money.
Right, but your client said he was going to be deported, and so this was a follow-up about his status.
He said,
one question.
He said that the complainant's father threatened to have him deported.
Right.
Now, that doesn't mean it's a valid threat, and it also didn't bring up whether his status was legal or illegal. Because someone can sponsor someone, he could just have clearly been saying, you know, I'm going to revoke my sponsorship. But there was nothing that invited the question by the prosecutor of whether you're in the country legally or not legally, because the defendant didn't bring that up in his testimony.
Okay. Secondly, you'd agree with me that both the victim's side of the equation and the defendants all had issues with English as their second language. In other words, this wasn't specifically pointed to the defendant as far as prejudice toward non-English speaking individuals, correct?
That is correct, but the prosecutor didn't continually question anybody from the victim's family about their inability to speak English.
Well,
I mean, I'm not sure.
Though, always on appropriate for a prosecutor or a defense attorney to question. So in other words, if I say, you know what, I'm allergic to coffee. Caffeine just gets me, deathly ill. And here I am seen drinking a cup of coffee. My credibility is at question, right? And if you hear somebody say good morning and then they claim that they don't speak English, isn't it fair game? It may not be worth much, but isn't it fair game to at least question the credibility of the person telling you that they don't speak English?
I don't think so, Your Honor, because I think most Americans would know enough to say hola or know a few words of Spanish or say de nada or say, if that doesn't mean you know how to speak Spanish because you know a few words. And I think that's similar. I mean, the fact that he knows the word good morning, like I said, would be equivalent to an American knowing hola means hello in Spanish. Does that mean you speak Spanish, or that it was proper to impeach him because he knows the word good morning? You know, I think it
Do you
was
think that's
just
enough to reverse a conviction?
not that. I think it's the real issue is bringing up his being in the country illegally. But I think there's also the cumulative effect in a case that came down to credibility of the witness and the defendant, the further errors of bolstering the complainant's testimony by Officer DeLuca and the remarks in closing, which were, he's an experienced investigator in sexual assault. And after doing this investigation, Mr. Santana was arrested. All of the errors in the briefing affected credibility of the witnesses. So I would say by itself, it was prejudicial enough to bring it as illegal immigration status. But it also, when they're also improperly bolstering the complainant's testimony, the cumulative effect of the errors denied Mr. Santana the right to a fair trial and fair jury.
Wouldn't you agree, though, this case and the officer's testimony was different from that which Stuckich indicated is improper?
Well, I think it goes to the heart of the same thing. There was no basis when Officer DeLuca was not a first complainant witness to present his testimony at all. But when the prosecutor mentions in her closing that he's an experienced investigator, and after his investigation, he's arrested. And then you look at the jury question where they then asked, what is the, what are the requirements to get an arrest warrant? Clearly, that remark stuck with them. There was no reason to call Officer DeLuca at all, considering he wasn't a first complainant witness.
Can I ask a couple of questions about this? I'm sorry to interrupt. I have a couple of questions, though. Am I correct that this Officer DeLuca testimony and the mention of the arrest warrant, there was no objection? So we're trying to figure out if there was a substantial risk. Is that right, Attorney Kelly?
I'm sorry, what about the substantial risk?
There was no objection to either having DeLuca testify or to the specific statements about arrest warrants.
That is correct.
Okay. So substantial risk, you agree, is the test?
Yes, Your Honor.
And as for the English language bit, I gather, I haven't seen how this is done, and I don't know if you were in the courtroom or are familiar with it. There was an interpreter there?
Yes.
Presumably. So every question that was asked of the witness was interpreted while the jury waited, and then every answer that the defendant gave was also interpreted back into English throughout the
yes,
proceeding.
I believe that is correct.
And when during this examination or cross-examination did the prosecutor ask about the defendant's ability to speak English?
There were several times, it was before the question about being here illegally. I have it cited in the record. There were several times she questioned.
And was there objection to that, or is your point just that that adds strength to the concern about the objected to question about immigration status?
The second, Your Honor, that it just adds to.
So it was not objected to at the time, these English language?
No, those questions were not objected to.
Attorney Kelly, you still have a minute remaining if you want to
Oh,
sum up
okay.
your argument. Mhm.
Yes, again, I think, like I said, this is on the prosecutor's closing arguments. This court, as I have cited, has brought up the improper argument, especially has the risk of prejudice when it's in a sexual assault case. And in this case, as I stated, when the whole issue comes down to credibilities between the complainant and the defendant, the combined cumulative error under Commonwealth versus Cancel should be basis for his convictions to be overturned.
Thank you very much. And before we hear from Attorney Lynn, I'm double check with the panel to be sure there's no follow-up questions for you. And I see none. Okay, thank you.
Thank you.
Attorney Lynn?
Good morning, Your Honors. May it please the court, Paul Lynn for the Commonwealth. I believe the trial prosecutor, ADA Amanda Paul, is watching on the Spectators channel. There are three crucial points regarding the defendant's, excuse me, Your Honors, regarding the defendant's argument that the prosecutor created reversible error by asking the defendant of his immigration status. The first is the defendant opened the door wide here by bringing up the circumstances of his immigration, and particularly that the victim's father threatened to have him deported.
I'm sorry, I don't understand that first point, Attorney Lynn. I'm sorry to interrupt you before your second and third point, but I don't understand.
I'm very used to it.
What's the, of course, I'm sorry about that too. What was the purpose of the question?
Well, the purpose of the question is it does give the defendant an additional motive to lie. Usually, if the issue has not been broached.
Wait, I'm sorry. His illegal status gives him an additional reason to lie.
Yes, because of course he can be deported for this crime.
So why can't we always ask, what does opening the door have to do with it?
Because ordinarily the risk of prejudice overwhelms the probative value.
Yes, I would think so.
Yes, and here though, we don't have that because the issue was brought up and discussed at length by the defense.
I don't see that. Can't someone with a green card be deported? The
answer is
yes.
The answer is yes, but this isn't going into in depth with the jury. This
Well, that's
isn't
not the point.
case.
The point is what he opened the door to was he deportable, not was he
Right.
legal.
That's
right?
Absolutely true. But he discusses the fact that
okay, so then that lets the prosecutor now ask a question, the answer to which you would never let in any other circumstance. I don't get it.
No. The reason is because it does have relevance, and the prejudicial effect is greatly reduced by this extensive discussion of the fact that the defendant is a recent immigrant to the United States.
I'm sorry, I don't see how his legal status has anything to do with that. I mean, I thought you were going to say something else that also I don't think makes sense.
Well,
I thought you were going to say he said he was going to be deported, so we checked to see if he could be deported, but that's helpful to him. That's not why the prosecutor asked. To make the story more credible, the prosecutor, as you're saying, I think asked because for some reason he thinks his illegal status is independently relevant, but I don't understand. I'm having a hard time at least understanding why it's okay in this case and not in every other. You don't think it's okay ordinarily, I assume.
Oh, ordinarily, as I say, the problem is that ordinarily the prejudicial effect of mentioning that the defendant is an illegal immigrant completely overwhelms the probative value.
And what's the purpose of the questions about can he speak English?
But that's a prior inconsistent statement. That wasn't. That's actually my second point, is that there's no reason, there's no hint of ethnic or language-based prejudice here because everybody in the family.
I'm sorry, it doesn't matter what anybody else is. He's a criminal defendant. They're not on trial. Maybe they should kick the family out too. I don't know. But they only get to kick out this guy. Right.
But we're going to the English statement. The victim's mother and father were witnesses for the Commonwealth. And we wanted the jury to believe them. So this isn't a case where there was any point.
Did you ask the victims? Did you ask the victims when they were on the stand if they could speak English or not?
No, because it was obvious.
It's obvious because they had an interpreter there that they couldn't.
Exactly.
And
Right.
this man had an interpreter there also making it obvious to me at least
Correct.
that he couldn't
But-
speak English.
Right. But what the prosecutor does is she asks, you say you don't speak English, but you said good morning.
So
And
you're
it's
a big liar. You kept us all waiting here. You're like a malingerer. You're making everyone wait for this translation, and it's a load of BS. I don't know. I mean,
I think that's grossly overstating the effect. I apologize for the statement.
Well, I hear you, but I don't
grossly-
know what jurors think about non-English speakers who have been here
Yeah.
for 10 years. I don't know what anyone thinks about that.
Yeah, it's overstating the effect of the question. The question is just, you say you don't speak English, but when you got in here this morning, you said good morning. Now, as Justice Walsh pointed out, that may not be, the most effective, shocking cross-examination.
In fact, if I may observe, it wasn't all that effective because he had a very good answer for that.
Yes, right.
Well, I don't know.
So
If
it's
it
a
was,
hard one to say
I
good
don't
morning.
know. I don't know if it was effective or not. He was convicted.
Right.
So I don't know. I don't know if it's an effective answer. So maybe he is a liar. Oh, you've been here for 10 years? Do you know some English? And you said you don't know any. I don't know. It's hard for me to say.
Right, but it's a valid course of cross-examination. How good a course of
So
cross-examination.
do you think it would have been all right for the defense counsel to cross-examine the victim's family? You say you don't speak English.
Yes.
Do you?
Well, if they had said good morning, or if there was some evidence that they
Well, I don't know.
spoke
That's
English,
not under oath or whatever. Good morning. I happen to hear them, so I'm going to check it out. Right?
I don't quite understand the question. I'm sorry. Your
Well,
Honor.
when did he say good morning? He wasn't under oath when he said it. It just happened by happenstance.
Right.
To hear him
The
say
jury
good
can-
morning.
The jury can consider what happens in the courtroom.
Okay.
Attorney Lynn, would you agree that it probably in hindsight would have better been left unsaid? Because there are other important issues in this case that I'd like to get to, but
Mhm.
would you agree with me that probably would have been better left unsaid?
I wouldn't go that far, especially regarding the English language question, because it was a valid ground of cross-examination. I think I would definitely agree with that regarding the immigration status question. It's certainly something that would have made this appeal much easier. But under the circumstances, it's not reversible error, and that's my third point. The second
Right,
point
can we
is
get
that
to your
the third point is this is a single a single question regarding his immigration status, a valid question regarding his ability to speak and understand English. It's neither of these are mentioned by the prosecutor in a closing argument, and of course the judge instructs the jury in no uncertain terms, this is completely irrelevant to the charges. It has nothing to do with the charges. And this isn't a case where the judge went back and forth saying, you can consider it as to whether he's a good person, you can consider it as to credibility. Here, the judge says
Let me
nothing but
interrupt for one
you
more
can't consider.
moment, Assistant District Attorney Lynn. When the jury was being impaneled, were they asked a question about their ability to be fair with an interpreter speaking, or any prejudice toward individuals who testify that are non-speaking, that don't speak English?
I believe so. I'd have to double check. I haven't gone back over the voir dire in preparation for this argument, but the jury voir dire, that is. But I believe I think there was a question to that effect, but I really would have to look that up. I'm sorry. But yeah, so it's just two questions in the course of the whole trial, not mentioned in closing argument and cured by the judge's instructions. So there is no reversible error here. Turning to the police issue.
Why wasn't there any, back to the illegal status, there was
Yes.
no mention or discussion of an instruction on prior bad acts or anything of that nature in this case?
No.
Okay.
Yeah, so we start with the substantial risk of a miscarriage of justice standard because there was no objection, and also the absence of an objection is some indication, not of course dispositive, but some indication that it didn't seem prejudicial at the time. And this is really the most basic of testimony. This is just yeah, we heard the complainant. We investigated the case. We got an arrest warrant, and that's really comparable to the cases where, the officer testifies, we arrested the defendant in a drug case. Well, of course they arrested the defendant. Of course they believed he was guilty. Otherwise, they wouldn't have arrested him. So I think that's.
You don't think that can order. I mean, I've seen that in sort of drunk driving cases, maybe in drug cases, where the police witness the actual crime being committed. But this is a question of an investigation, and there's all this case law about official imprimatur through believing the witness, and particularly the limitation on first complaint is in part about that. Isn't this more like that? I know it wasn't objected to, but should he be saying he got an arrest warrant? And in closing, should the prosecutor be saying, he got an arrest warrant?
Again,
also, adding to that is that there was a significant passage of time between the events at issue and the reporting.
Correct.
So
yeah, 7 years.
Definitely, would you not agree that by the indicating that an arrest warrant, or stating that an arrest warrant was obtained after that period of time, that at least this police officer had come to a conclusion with respect to this, to the defendant's guilt?
Yeah, and yes, I think that's fair to say. I just think it's certainly not the kind of prejudice that would cause the jury to say, oh, wow, this guy must be guilty, even though I would otherwise doubt his guilt.
But do you agree it was error, or you think it's okay?
It's a close call. It really is, because it's the officers can certainly testify to what they did. It just whether they crossed the line as to suggesting this official imprimatur. And it is a close call.
So if they did, your burden is to show that this didn't materially influence the jury's deliberations.
Yes, there's the
risk. And they ask a question about it.
Right. And the judge responds to that question by saying, no, you can't consider that. There was no evidence.
The judge doesn't say you shouldn't have heard it or strike.
No. He certainly says, no, don't consider it. And this isn't a bell that is so loud that it can't be unrung. This is just.
Well, it's pretty loud if they're asking a jury question about it, right? I mean, we rarely know what goes on in the jury room, and I frequently wonder what goes on in the jury room. But
it's a fair point, but you have to come to the. It's not reversible error in these circumstances unless there's a substantial risk that it affected the jury, and where they have this question and their question is answered by saying, no, you can't consider that. There's no substantial risk of a miscarriage of justice, no substantial risk that where they're, I mean, I'd say rebuke, that's a little strong, but where their curiosity is, they're told that their curiosity is unwarranted. That they went back to the jury room and said, well, we're still going to consider this and still going to use that as the basis of our guilty verdict is implausible. Are there any further questions, especially regarding the second issue, which I know we haven't touched on?
Why don't you go ahead?
No, I would otherwise rest on the Commonwealth's brief.
Oh, I thought you wanted to say something more about the second issue. Okay.
No, just wondered if the court had any questions about it.
Oh, all right. I misunderstood that. I apologize. So I'm just going to check with the panel, see if they have any additional follow-up questions. And seeing none, you can rest on your brief, and thank you both very much for.
The case is now being recorded.
Okay, thank you very much. Good morning. This is case number 2021-0494, EB versus UO. I remind the parties that this case is partially impounded, and you're both aware of that, so please be careful in terms of using any names. Just briefly before we start, in case you're not used to doing arguments on our Zoom platform, it's the same as being in the courtroom as much as we possibly can make it. But most importantly, the same rules of oral argument apply to this form of argument as those that apply if you were in the courtroom. So you each have 15 minutes to present your argument, and there is no rebuttal. All right. Your panel today consists of myself. My name is Ariane Buno. I'm joined today by Justice Peter Rubin and Justice Maureen Walsh. So Attorney Nevsip, I believe you are the appellant. Am I correct?
No, Your Honor, I'm the appellee.
Your appellee, okay. Ms. Attorney Siddle.
Thank you, Your Honor.
Okay.
May it please the court, I'm Megan Siddle. I represent the appellant UO, who I note is watching on the live stream today. Okay. As I did in my brief, I will refer to my client as husband and the appellee as wife. We ask today that the court vacate the restraining order entered against husband on November 18th, 2020, because there was insufficient evidence that husband abused wife under either sections 1A or 1B of chapter 209A. The district court found physical abuse took place on May 8th, 2020, and that husband exhibited, quote, extremely controlling behavior. I'll begin with the May 8th, 2020 incident, which was the event that precipitated wife's complaint and was the primary basis for the district court's decision to extend the ex parte abuse prevention order. The district court erred in finding that the May 8th, 2020 incident met the definition of abuse under either sections 1A or 1B. Section 1A defines abuse to include attempting to cause or causing physical harm. Even if the court accepts, which we dispute, although I understand on appeal, the court may defer to the district court's credibility findings here. But even if the court accepts that there was physical abuse on May 8th of 2020, there's no evidence that wife was continuing to suffer from physical harm on November 18th, 2020, at the time of the extension hearing, which was about 6 months later. An abuse prevention order may be extended due to past physical abuse in two circumstances. If the complainant proves that additional physical harm is imminent, that's under the Smith case cited in my brief, or if the complainant proves that there was actual past physical abuse and that she reasonably remains in fear of the abuser continuing to suffer the effects of that abuse.
I don't understand why that second one. I think the second one is what the judge found, probably. I find the findings, I'd like them to be a little crisper than they are, frankly, but it looks like that's what the judge was saying, because the judge didn't use the word imminent anywhere. So if that's what the judge found, where's the error? How can you deny? She said she was in fear, right?
Mm-hmm. So to start with, Justice Rubin, I tend to agree it's likely that the court made her findings under section 1A, although it's a little bit unclear to me, which is why I argued both in my brief. The wife does testify at the hearing that she's in fear of husband who's sitting at the hearing at the time. But there's a few reasons that testimony should not have been credited. Well, okay, first of all,
now you're telling me it's not credible. That's all you're telling me. You're saying, I think you're going to say, I don't mean to interrupt you on this point, but it seems like, you're going to say, but she let the kids be picked up at the house. But she said, why don't you call me if something happens? But the judge can still find she was in fear, notwithstanding that. I understand that undermines her credibility, but we don't. We're not in a position to review that.
Well, that is one of my arguments, that her conduct since the May 8th incident does not suggest that wife was actually in fear. My other point would be that generalized apprehension under the cases is not sufficient to extend a restraining order. And I think the evidence shows very clearly that there's been a dramatic change in this couple's relationship since May 8th. May 8th is sort of the worst incident that wife reports. And, we dispute what happened on May 8th, but even if the court credits that, that was the height of it.
I'd like to ask you about that, because you began your argument by saying, even if we conclude that that was physical harm, do you concede that that's physical harm?
I don't concede that that's physical harm. For example, it's a fleeting incident. It's clear under the security camera records that husband is in wife's room for approximately a minute. She testifies at the hearing.
Physical harm in a minute, obviously. So I guess what I'd like to know is what amounts to physical harm. Obviously, it doesn't have to be serious physical harm, because that phrase is used elsewhere. What counts as physical harm? Is any touching physical harm? What is physical harm?
in my view, it would not be any touching. And here you have a very ordinary routine touching between spouses. Husband is gently shaking wife on the back.
And then
in an effort.
pokes her in the back, she says, or pushes her in the back, I guess is her actual testimony.
Her testimony at the hearing is that he started to push her.
And in the affidavit, which could be considered as well, it says pushed her, I think several times with increasing strength. Is that, if the judge believes that, is that physical harm?
I don't think that's physical harm. There's no evidence that wife suffered any pain, that she suffered any bruising, that she needed any medical attention.
So you think physical harm requires pain?
I would think it requires some sort of injury of some kind.
A slap in the face?
Yes, that would be pain. I think that would be an injury as well.
That would cause physical harm. So a slap would cause physical harm. That seems right to me.
Mm-hmm.
Now we're talking about increasingly strong pushing. What is it about a slap that you think is the physical harm? It's the pain. Is that right?
I think pain would be physical harm, and I also think causing physical injury.
Well, physical injury, I'm not sure I fully understand what that means. So sometimes someone twists their ankle and it hurts for a minute. It's not a sprain though, it just hurts for a minute. I guess they have injury, I would think. Do you agree with that?
I think so, yes.
So it's a question of how long the sensation lingers for? Is that what it is? If you still feel it after the contact has stopped, that's injury?
Well, I think the difference between a sprained ankle and what happened here is that there
I said it wasn't
some pain.
sprained. It was twisted, hurt briefly for 45 seconds, but then the person walks it off and it doesn't hurt anymore. But it did.
Yeah, so in that instance, there is some physical pain. There's no allegation that there's any kind of pain here or any kind of mark left on wife. There's no bruising.
No, there's no bruising. I don't know if there was any kind of mark. No one looked at the skin under whatever she might have been wearing or whatever he was poking, if he wasn't poking her skin directly.
Well, it's wife's burden to prove that there's physical harm, and wife's testimony did not suggest that there was any sort of bruising or injury that she suffered. I think that the problem here is that there's incidental contact between spouses on a regular basis, and I don't think the court.
It's not incidental. There's nothing incidental about it. It's not like he inadvertently jostled her while going to the fridge. I think we would say if you shake someone to wake them up, to tell them or ask them to do something, that's not physical harm. This went beyond that, clearly went beyond that to poking or pushing. That is, the judge could have found anyway, according to her testimony, to physical pushing with increasing strength.
So
I don't think anyone would say that's okay. I'm just trying to figure out if it's physical harm.
So I think, so first of all, I think that's what wife says in her affidavit. Her testimony at the hearing is actually much more circumspect, that he just started to push her. And that was the live testimony that the judge was observing.
The judge has the affidavit. They're not really inconsistent statements. They're, you know what I mean? I mean, I don't know how someone says it colloquially.
I'm not saying they're inconsistent. I just think it's milder than what she says in the affidavit. But
if it were, it seems to me, someone could maybe, if this happened in certain circumstances, this could maybe support a criminal charge of assault and battery. Do you agree with that?
I don't actually think so here, because so at most, husband touches wife, as he starts to push her, and it would be a defense to a battery charge that he would have had consent to touch his wife. And, obviously at the moment, wife hasn't consented, she's asleep. But I think in the course of a marriage, there is, and I don't think the court wants to get involved in litigating the fine details of contact between spouses.
I think the court very much is involved in that question appropriately, very involved in that question, right? All day long, we have to worry about unwanted contact between spouses. It's serious.
That really is the crux of the issue here, because she's testifying and she's alleging that this was a serious event. So much so that that she got up and left.
Well, she walks into the next room, into where her mother is sleeping.
Right. Potentially seeking some protection.
Yeah, that's not what she says, but the court might have inferred that. So I think the crux of the issue is really whether in November of 2020, the wife is still fearing ongoing physical abuse, or whether she's suffering from the effects of what happened on May 8th.
Merely being in fear of him, though, is sufficient for that.
I don't think generalized fear is sufficient for that.
I'm not sure I know what you mean. What is generalized fear versus fear?
So for example, under, I believe it's I'm forgetting the name of the case at the moment. It is, so simply saying that you're afraid of someone without being afraid that they're going to hurt you or cause physical harm is insufficient.
So, counsel, but you'd agree with me, the cases that talk about the general apprehension and fear go to cases in which there is no physical abuse or attempt at physical harm. It's that third prong, the imminent fear of serious bodily harm. And what the court has said is that a generalized apprehension of, I don't know what he's going to do, I don't know what he's capable of doing, I'm just afraid, is not enough to for a judge to issue a restraining order. Here, if you accept, and it's a credibility question, the version of events by the wife, then there was physical abuse, there was physical harm. And so, for example, if you were stabbed 10 years ago, 30 times over various parts of your body, 10 years later, for an extension on a restraining order, you don't need to show that you were stabbed again. You can say that event was so troubling, I was so afraid that even now I'm scared. I have a fear. So it's not just as generalized. The generalized apprehension has to do with just no physical harm, no threats. I'm just afraid of what he possibly may do if he finds out I spend too much on the credit card, example, right? So this one is different. Once the wife, if believed, establishes physical abuse at a time, then the question is whether the continuing need for the restraining order is supported by the evidence. And it's a preponderance of the evidence standard, correct?
Yes.
It seems to me that you disagree with the credibility findings of the judge. By the way, I thought your brief was excellent. I thought your written skills were excellent. But in this case, you're really fighting with the judge's findings, which we give great deference. But I did want to note for you that I thought you did a tremendous job for your client, and your skills were top notch.
Well, thank you, Your Honor. And if I could just comment a little bit on your statements there. There has to be some limit on when the court can continue to extend restraining orders. It can't be the case that anytime there's an instance of physical abuse, the complainant can get an extension, 10 years later. I would agree in an incident as severe as multiple.
This is 6 months later. There's evidence in the record. I don't know if it's true or not, but the judge certainly could have believed it. Evidence that the defendant said he had hit prior partners in earlier relationships. I mean, this is not I don't think the fear, if you believe the wife, I don't think the fear question here is as close as you say.
Well, I think the evidence about everything that's happened since May 8th is that the tenor of this relationship has changed dramatically. Husband has filed for divorce. He's obeyed the restraining order. There have been no allegations of additional attempts to cause harm to wife. And I see my time is running out, but we would submit that wife did not prove that she was continuing to suffer from physical abuse in November 2020.
Thank you very much. And I hope you appreciate the fact that we push hard in these cases and ask a lot of questions. And we do that so that helps us arrive at the appropriate resolution. So now we'll hear from Attorney Nevcev, and you may get some tough questions as well.
Thank you, Your Honor. I look forward to it. May it please the court, my name is Maxim Nemtsev, and I represent the appellee EB, who is also watching on the YouTube live stream. And obviously, this court's decision is very important to her. I want to start off with the last of Attorney Siddall's arguments that the tenure of the relationship changed from May to November up to the point where there's no longer a continuing need for the restraining order. I don't believe that's a fact. After the restraining order issued, the husband continued to monitor the wife's activities by accessing her Facebook account on 2 occasions from an address in Cambridge where he was believed to be staying. He filed a divorce petition, which wasn't an attempt to amicably resolve the parties' differences like the appellate's brief suggests. Rather, he initially, as soon as he filed divorce, he also filed for sole legal custody of the children, even though the wife and her mother were the principal caretakers of the child throughout their entire lives.
Rather than talking about the change or lack of change of tenor, can we start with the May 8th incident?
Yes, Your Honor. So the May 8th incident.
What makes it, how would I put this? Is all pushing physical harm within the meaning of the statute?
I think it would be, Your Honor, if it's unwelcomed, if it's unconsented
to. And is that, how would I put this? Is it also criminal assault and battery? Is that why it's physical harm?
It could be, Your Honor. It could be a criminal assault and battery, and it could also be physical harm because it's unconsented to, unwarranted under the circumstances, not incidental, not accidental. This was purposeful, Your Honor. He gets out of bed on.
The only problem I'm having, I fully agree with you. I think it probably is criminal assault and battery, probably, if it were proven, and so on, and charged and so on. But the statute, for some reason, doesn't say unconsented touching, right? Which is the standard for assault and battery. It says physical harm. And it's obviously, or maybe it's not obvious, but to me, it's obviously wrongful, maybe criminal behavior. But what is that physical harm all about? And do we have a case, actually, as the real question, where pushing that didn't cause even, because there's no testimony about pain, is still treated as regardless, whatever, you can't do this, and it counts as abuse under this statute?
I don't know of any case off the top of my head under similar circumstances where someone who was pushed unprovoked, unconsented to, didn't testify about the injuries. There were, unfortunately, there were no questions regarding the injuries, whether there was bruising, whether there was need for medical attention that was ignored.
It seems smaller than that, but that doesn't bother me. I don't think you need bruising before it's physical abuse. I don't think you need medical attention. But I assume we're in agreement that jostling someone to wake them, like gently, and I don't know what the word other than sort of appropriately, you know what I mean? Your spouse is asleep and you're like, I think I heard something downstairs. And you say, sweetie, wake up. And you jostle her. I don't think anyone would say, what kind of physical abuse is that? right? But this goes beyond that. First of all, do you agree with me that that jostling might not be physical abuse?
I agree with you, Your Honor. But jostling gently when your spouse is asleep to try to wake her up wouldn't be physical harm, in my opinion. But here it's
so we leave it to the trial judges after hearing whether, in this instance, for example, a husband grabbing a wife's hand to walk down the street wouldn't be abuse, but a husband's grabbing of a wife's arm and pulling, the circumstances will can't be easily defined, but I think a reasonable interpretation of what physical harm in the definition of abuse is applied at every stage of the proceeding. So in other words, if a husband pushes the wife out of the way from a running train, of course that wouldn't be abuse, right? So under the circumstances, that element has to be met. And your argument, counsel, is that if you believe the wife, certainly the violent awakening, given the description, is enough to sustain the preponderance of the evidence burden. Is that correct?
That is correct, Your Honor. And not only is the May 8th incident alone enough, but also all of the circumstances surrounding the relationship, including the prior acts of physical violence and verbal abuse that the wife suffered, that's supported at least in part by 2 police reports, as well as the text messages that were submitted, as well as the affidavit of a friend that was submitted, as well as his conduct after the issuance of the restraining order.
So are we supposed to, I'm just trying to figure out how we're supposed to define this. Right, I appreciate Justice Walsh's observation that it's hard to define, but it has to be defined, obviously, because a restraining order is a serious consequence. Now, maybe the answer is in the criminal statute, we just incorporate that. I would think that, and I haven't, looking at this case, I haven't looked through all of our criminal assault and battery cases. I would think that it would be an unconsented to touching that isn't justified, right? So for example, maybe the jostle is consented to. Maybe it's a little tricky, the person is asleep, but maybe we all sort of consent to our spouse waking us up in case we miss work or something. I don't know, right? But and I don't know if we consent to being pushed out of the way of a train. But if we don't, at least we wouldn't prosecute someone for it. We'd say, well, that's justified by protection of the safety of another or something like that. I mean, I'm not saying, I'm saying, should we be incorporating all of this nuance in here so that we can draw a line between, and should it include intent, right? The intent of the increasing pushes, for example, in my view, might be said to be, he's not trying to wake her anymore. She's awake. Now he's just pushing her. Now he's just assaulting her. And so maybe that I'm just trying to figure out, it would be nice if we had a way of drawing this. Well, we need a way of drawing the line. And I'm not even sure that pain or red marks or anything like that is necessary for these to be wrongful. Maybe pain is inherent. I don't know.
Your Honor, I think that's, I'm sorry.
I've got a follow-up question. I think I understood you to say, and that, and preempting a response to Justice Rubin's comment, to say that the verbal abuse and the overall tenor, if you will, of the relationship informs us or informed the judge of how serious an incident or not on the May 8th instance was. Am I correct?
Yes, Your Honor. And not only that, but also the continued need for the order in November.
Okay. All right. You also said, and I have some questions about this, that also corroborated by the 2 police reports. Now, no police officer ever actually witnessed anything. Is that right?
No police officer witnessed anything. One overheard in one of the reports a yelling coming from the house.
Okay.
And the wife did testify that she didn't report prior instances of physical abuse, including,
There certainly were reports, and there was two police reports submitted here. But again, it wasn't anything that was directly observed except for that one incident of overhearing yelling.
That's correct, Your Honor. The police were called after the fact, and they came, and at one instance they heard yelling, but they never witnessed any physical abuse or
and no arrest was made.
No arrest was made, and the wife left the home first time for weeks and the second time for years.
Do you have thoughts on my question about how to define this? And I ask only because I agree with Justice Fiano, who's described this as serious, and that sounds right. And Justice Walsh, who said, sort of, we know what this is, even though it's hard to define. But we do have to give notice and, and tell lower courts how to define it.
I understand the difficulty, and I think it's a very difficult, complicated analysis, and I doubt that there is ever, a bright line that could really be drawn to determine whether something constitutes physical harm under 209A or not. Certainly, I believe that if conduct would be criminal, then it should qualify as harm as well. But under these circumstances, I think the district court judge is honestly in the best position to analyze the circumstances of the assault, to the tenure of the parties' relationship, and determine whether there was physical harm.
Yeah, but we can't, it's not a rule of law if it's I know it when I see it, right? That's no good. Right, I know Justice Stewart said that one time about obscenity, but that's not actually I know it when I see it is not a good way to give everyone a clear, including potential defendants, a clear indication of what you can do without risking a restraining order. And I'd like it to be clear. I like the idea of if it's criminal, that seems helpful, maybe, but it obviously doesn't. I don't think it has to be criminal, or maybe. I mean, I don't know.
I agree with you, Your Honor, that certainly if it's criminal, then it should qualify. Maybe there's an alternative standard if it would shock the conscience, shock the ordinary person, something of the sort, conduct that would be unreasonable to the ordinary person. Maybe there is a way to somehow clarify these definitions and how to apply them for the district court. In this case, I think the conduct that the district court determined in the 8th incident, everything else surrounding the parties' relationship was sufficient to extend the order in November, especially in an extension of only 6 months.
Counselor, you would agree with me. I mean, there are two subsets of 209A. One is causing or attempting to cause physical harm, right? And then the language in the third clause, if you will, is, or second, depending on from which you're reading, is an imminent fear of serious bodily harm. So when it's just fear, the standard is higher. It's serious bodily harm, not just bodily harm. And when it's physical harm, doesn't say serious physical harm. Isn't that important for us to consider?
I think it's an important distinction in the law, but I think for our facts and our circumstances, a decision was made by the district court judge that physical harm had occurred. She described in her decision that the May 8th was a
physical harm, right? It just says physical harm.
I believe it was quote unquote physical assault. That she's the words that the judge used. But I agree, there's a distinction between the two, and under 1B, you could obtain an order without any physical violence, without any physical contact, erratic behavior, escalating tensions would be sufficient. And there's many cases that we even cite in our brief where that has occurred.
You don't think the judge made that finding here, though, do you?
I don't believe so. I believe she focused on the actual physical assault, but I believe that even if she was solely focused on 1B, the conduct, especially after May 8th, would support an order as well.
You don't think that we could affirm on that ground? That would have to be, there's a fact that was never found, right, about whether there was fear of imminent physical harm.
There was no findings of imminence, I believe.
Yeah.
But there was findings of continuing need based on the physical harm that happened on May 8th.
Well,
thank you,
Counselor,
Your
I
Honors.
see your time is just about up with 8 seconds left. I'm gonna assume you're gonna forego them, but I won't take them away from you. Well, I'm about to take them away from you because here you go, 1 down to 1. I will always, as I always do, check with the panel to be sure that there's no follow-up questions. No, okay. Well, I want to thank you both very much again. Both the briefs were very good. The arguments were very, very helpful. No matter how it comes out, I think we can all agree that these cases are always serious, and we will give it our attention and get an answer back to you as soon as we can. All right.